Thank you, Chair. Good afternoon, ladies and gentlemen. I feel like I'm home. I moved to Australia 7 years ago. Before that, I was working at IDSA for almost 5 years. And actually, it's for the first time I'm speaking from an Asian Security Conference Forum. So thank you very much for giving me the opportunity, Ambassador Gupta, Uttam. Having spent 38 years in this country before I moved to Australia, including 18 years of research experience and 5 years of research at IDSA, I think I find myself in a very unique position that now that I have moved to Australia with the understanding of Indian security issues, I find it very interesting and useful to use my Indian understanding of security and strategic issues and draw upon the expertise which is there at the center in Australia at Griffith University and SEPS, and work on the issues which are common to both India and Australia. So keeping that in mind, this is first of the initiatives which draws upon perspectives from India and Australia on issues of common nature, that we decided to look on the area-specific laws in India. There are nationwide, nation-specific laws, and there are area-specific laws, and there are state-specific laws. In this regard, we chose to look at the area-specific law, and that is the use of force, and also the recent developments and amendments in the anti-hijacking laws in India, because Sam and I, we have been sitting and discussing, and we said that it would be interesting to look at how different countries, different democracies respond to a situation like a hijack, and what are the security forces and armed forces entitled to do. And clearly, I remembered the experience that the SAT experience the whole nation had in 1999. So that helped us zero on the anti-hijacking laws as well as a part of this paper. Ladies and gentlemen, Australia-India relations have come a long way since the 1990s, when they lacked warmth because of the nuclear test. But over the last decade, bilateral engagement has intensified across various fields. But the major leap came in 2009, when former Prime Minister Kevin Rudd came to India, and the relationship was elevated as strategic partnership. So within that, a joint working group on counter-terrorism was also established to provide and buttress cooperation in the security and defense field. You will agree that both India and Australia, though in varying degrees, are victims of terrorism. And many of you may be surprised that the first act of terrorism in Australia actually was in 1977, when a member of the Anand Marg kidnapped the Indian Defence Attaché Colonel Iqbal Singh and his wife to avenge the arrest of their leader Prahat Ranjan Sarkar by the Indian government. That was in 1977. And after that, Australia faced a number of terrorist attacks, including 1972 bombing of the Yugoslav General Trade Agency in Sydney, then 1970 bombing of the Sydney Hilton Hotel, then 1980 assassination of the Turkish Consul General in Sydney, 1982 bombing of the Israeli consulate, and of course the Bali attack in 2002, in which 88 Australians were killed. And Australian troops in recent decades have been deployed in various conflict theaters, and at the moment they are still in Afghanistan, and which makes the Australian citizens and the defense forces and the government a target of various terror outfits. In Afghanistan itself, Australia has lost over 40 soldiers, and 261 have been injured. Within Australia, homegrown terrorism remains a key concern for the government, and in recent years, this has led to the prosecution and conviction of over 35 people for terrorism-related offences. India has its own sad story, which we have all seen in the last 20-25 years, having lost 63,000 people in terrorism-related violence, at the hands of various jihadi groups who have been coming from across the border and also now from within, described as the homegrown terrorist groups, and also the left-wing extremists. And we all remember the 1999 hijacking of the ill-fated IC-814, which finally landed in Kandahar after India agreed to release those three terrorists who were imprisoned in India at that time. Now, after following the Mumbai attack in 2008, India confronts a triad of terrorist threats from the land, sea, and air. Internally, the Indian government, to deal with internal disturbances in Jammu and Kashmir and in the northeast, has deployed its armed forces. And the prolonged deployment of the armed forces, you all must have read in the reports and in the newspapers and across various academic studies, has fueled a bitter acrimony and tension between New Delhi and Jammu and Kashmir and northeast. As a result, now the Indian government is contemplating maybe the repeal or the modification of the Armed Forces Powers Act, which was passed in 1958. And also recently, a couple of years ago, in fact, when the Indian government also passed the amendments to its anti-hijacking laws of 1982. But I will submit this, that it is indeed a very difficult task. This is what we've also realized in the study with regards to Australia, that it is very difficult preserving the nation's integrity and interest on the one hand, and on the other hand, assuaging international concerns and national concerns with regards to human rights violation. And it is very critical and difficult to get that the balance right. And in this regard, Manmohan Singh said, we are ready to learn from international experiences. There is indeed quite a bit of divergence in internal security threats, both in scale and nature, between India and Australia. But nonetheless, I think parallels can be drawn from the respective legislative frameworks that facilitate the domestic deployment of armed forces in crisis situations to aid civil power, and what are the safeguards within which they have to function, and what are the restrictions on the use of force when they are in action. And the most salient lesson that comes to the fore from India and Australia is that in the aftermath of any terrorist incident or any crisis, it leads to an overbroad emergency powers legislations, and scant attention is given to cost-effective reasonableness and proportionality, and that leads to a spate of human rights violations and excesses by the security forces from time to time. So in this paper, what we are trying to do is that how can modern democracies like India and Australia combat their internal security challenges effectively, while at the same time remain compliant with international treaties, conventions, constitutional and also domestic laws in respective countries. The AFSPA, the Armed Forces Special Powers Act, which was passed in 1950, I don't want to go into that too much in detail. This august audience is aware of the provisions and the history. But just to flag briefly that after 1947, we had 4 ordinances which were passed and which were replaced by the AFSPA in 1948. Then the 1958 Act came, and then we gradually saw the deployment of the forces in the northeast, and then from 1990 onwards we saw the deployment of forces in Jammu and Kashmir in what was deemed as the disturbed area. So AFSPA confers special powers upon the security forces in the disturbed areas in the northeast and in Jammu and Kashmir, and empowers them to use force and carry out arrests, searches without warrant, and effectively suspending habeas corpus. It empowers any commissioned officer, warrant officer, non-commissioned officer even, and other persons of equivalent rank to fire upon or otherwise use force, prohibiting assemblies of more than 5, arresting people carrying weapons, the whole lot of powers that are conferred upon the security forces in the so-called disturbed areas during their deployment. But what has drawn most criticism of these acts is both nationally and internationally is that the act confers on the security forces the power to arrest, enter and search without a warrant. And interestingly, the act says that the arrested person or the detained person who is in custody should be handed over to the nearest police station with the least possible delay. We have a similar kind of provision in the Australian law legislation as well, which Simon will refer to soon in his presentation. But what is most criticized is the immunity that the Act gives to the armed forces, and when it says that no prosecution, suit or other legal proceeding shall be instituted except with the previous sanction of the central government against any person. So generally speaking, it is the derogation from the right to be brought before a competent court to answer charges without delay and to contest the legality of detention and sweeping powers to the security forces lies at the core of the controversy and criticism, not only from India, also from abroad, of the Act. In India, you are very well aware, ladies and gentlemen, that the opinion remains deeply divided. On the one hand, you have the Ministry of Defense, including our Minister and the Chief of Army Staff, General Vikram Singh, who say that we need to look at the developments in Afghanistan in 2014, what shape it takes, before perhaps tampering with or diluting the Disturbed Area Act. General B.R. Raghavan, who was former Director General of Military Operation and who was also a member of the Jeevan Reddy Committee, which looked into the, which reviewed the ASPA Act, he said in an article which said, "Don't blame the law," he said, if ASPA's enabling powers are to be revoked, diluted or made subject to normal processes of law, the military will conduct operations not on the basis of military judgment, but on the need to defend its actions in courts. However, because of the criticism which has been raging in recent years, not only from the Northeast, also from Jammu and Kashmir, now we have seen that the Indian Prime Minister, former Home Minister Mr. Chidambaram, and the current Chief Minister Mr. Abdullah, they all have recommended reviewing the provisions of the Act. The Home Ministry is also suggesting that we should align AFPA provisions with the Criminal Procedure Code, something which they have been talking along the lines of what the Jeevan Reddy Committee has been suggesting. Across the country, especially in the Northeast, we have seen a large number of protests have been occurring over the years, in which students, NGOs, civil society groups have been protesting against the for the repeal of the ASPA in the region, and that has only intensified after 2004, when in Manipur, Thangam Manorama was detained by the Assam Rifles and allegedly raped and shot. That led to the, I think, the creation of the committee, the Jeevan Reddy Committee, to look into the feasibility of reviewing or repealing it. And internationally also, there have been criticism being leveled over the years. We had Christoph Heinz of the United Nations Special Rapporteur on extrajudicial summary of arbitrary execution, who visited India and went to Jammu and Kashmir and also Assam in 2012. Now, the report which was put forward after his visit, it had two major concerns. First was the use of lethal force by the security forces under Section 4, and second, the broad protection provided to officers under against prosecution under Section 6, Section 6 of ASPA. The report also pointed out that the acts of the ASPA were not in compliance with international standards when it came to protecting human rights and right to life. And it noted that it confers more powers on the security forces than they are generally entitled to in an emergency situation. And it said that retaining a law like ASPA runs counter to the principles of democracy and human rights. So you can see there have been international concerns, and it was not only this report. There are a range of other reports which have been looking at the allegations of abuses and excesses from time to time, which are being reported in the Indian media. And the Justice Jeevan Reddy Committee itself, which was constituted in 2004, it came out with a very sharp criticism, of which, in fact, General Raghavan, who said that don't blame the law, who was also a member. And the report, in very clear terms, the committee in clear terms said that the deployment of armed forces ought to be an exception, not the rule. And then we also had, it also said that the armed forces should be held accountable, and then AFPA should be repealed. Now there were several recommendations by the committee in which the Ministry of Home looked at, the government was looking at, and some of which are basically an effort to try to bring them in compliance with international standards when it comes to human rights. And speaking about the anti-hijacking laws, in just a few minutes before I hand it over to Simon, I think the Anti-Hijacking Act which India had of 1982, which was amended in 2010, and after the amendment, the new new amendments now empowered the Indian Air Force in the Indian space to use force to shoot down an hostile plane if there was conclusive evidence that it is likely to be used as a missile to blow up strategic establishment. So after that, I was scanning the Indian media. There was a debate going on. Even there were hostages from the 1999 crisis who had come forward and who were questioning the new policy and amendment of shooting down an aircraft, and a government of India no negotiation policy with the terrorists and the hijackers, saying that it was because of the negotiations in the 1999 crisis that the lives of so many passengers could be saved. And there are some experts who have been saying instead of no negotiation policy, government of India should be having a no capitulation policy towards the hijackers. So there's a wide range of opinion on these amendments. So on these, I thought it will be interesting to see how does the Australian legislation and law look into these circumstances and the use of defense forces to its civil power. So with these words, I'll invite Simon to bring his perspective from the Australian context. Thank you.
Thank you. I'd like to thank the director for inviting us to the conference, and to the chair for taking the time to chair this session. I think it's very important, in light of some of the responses that are going on here, to make a statement quite clearly that we're not intending to enter into this debate about the Armed Forces Special Powers Act. That was merely by way of context to give what I think is really important, which is that we need to shift debates about the use of the military away from a discourse that is using human rights and international law to critique it, to look at comparative law, to look at what we can learn from other jurisdictions about how and when and under what conditions the armed forces are used domestically. And in that respect, I came to India to share some lessons in relation to that. And I think they're very pertinent. It's quite clear that Australia, like many countries that inherited the British model of law, approached internal disturbances with a combination of martial law, reading the Riot Act, and also warlike powers, wartime powers, emergency powers. And as Ashutosh pointed out, the beginning of our journey with developing a more modern and what I would say is a human rights friendly approach to the use of the military domestically occurred in the 1970s following the Anand Mag alleged attack in relation to the Hilton bombing in 1978. But it became clear in the run-up to the Sydney Olympics that this model that we were developing in relation to the use of the call-out powers, we call them calling out the troops, was not really modern enough to cope with the nature of the modern terrorist threat. So we created a legislative framework within our Defence Act. We inserted something called Part 3 AAA, which if you read it, and it's a very extensive piece of legislation, and in that respect differs from the Armed Forces Special Powers Act, because it tries to work at the level of detail of guiding decision-making of all the players in the process. And I think following the 9/11 attacks, it was further reviewed, recognising that the earlier legislation had been modelled around a hostage siege scenario. And of course, as we know now, that sometimes the military don't have the time to invoke a civil chain of command, consulting with in our case, the Governor General, the Prime Minister, Ministers of State, before they exercise a use of force protocol. So it's very clear that they had to adapt to what is obviously the modern threat, which is a mobile terrorist situation that is unfolding very quickly. And so we amended our laws in 2006 to be clear as to what the powers, responsibilities, and immunities, and I think that's one of the key points that have come out of the Australian experience, is that there is a need to provide both powers and immunities, but have them circumscribed. So in our situation, we're going to focus, because I think it is a fairly contentious area legally, is the power to destroy a hijacked aircraft. Imagine 9/11 occurred again today. And this is certainly a scenario that many countries have had to deal with. It's a very fraught decision. Information is always going to be patchy. There's going to be conflicting views as to what is happening and what is unfolding. And planes move very quickly. And it's very clear that the decision-making processes around this have to be made swiftly. And in that respect, Australia has moved to set up a framework of prospective authorisation of use of force, designating specific areas, specific places. They're not actually identified publicly. There's a process by which key critical infrastructures, and that comes back to the theme of this session, key critical infrastructures are designated, so we can presume these will include major military installations, they'll include major political sites, such as Parliament House, as well as utilities, gas, and I suspect also key cultural sites of significance, like, say, for example, Sydney Opera House. But it's very clear that these critical infrastructures are able to be designated beforehand, and that the military in those situations will be able to exercise their powers proactively. But before I go into any more detail on that, I just want to set out the principles that are contained in the Act, because they're very important. They set out, in a sense, the purpose behind setting out Part 3 AAA. And they were that the ADF, the Australian Defence Force, should be called out in aid of civil power as a last resort, where civilian authorities are unable to deal with the situation. Where they are called out, the Defence Force, where the Defence Force is called out, civil power remains paramount. So there's no essential suspension of civil law. They're working within the framework of the law as conferred by Parliament. Civil power remains paramount. At the same time, the ADF are not placed under civil command. The key point about decision-making is it's taken within military command. So all of this is clarified by our legislation. They can use force, but they can only use force that is reasonable and necessary in the circumstance. And ultimately, the purpose of the Act is to make sure that the ADF remains subject to the law and accountable for their actions. So these are very important enabling tools. I think in a crisis, particularly crises where you may not have a template of past experiences, that you have a framework of that will guide decision-making. So in relation to this, there are a number of different domains. In some situations where there is an opportunity, when it's not a situation of exigency, you will have decision-making through a chain involving the Prime Minister, authorising ministers, that will give power to the Governor-General to call out the troops. Of course, this is in a situation where something is like a siege, where there's a time to allow people to make those judgments. In situations of exigency, the military can act without that, obviously without that required approval. It does also say that, and there are safeguards embedded, that the Chief of Defence Force must not stop or restrict any protest, dissent, assembly, or industrial action, except where there is a reasonable likelihood of death or serious injury to persons or serious damage to property. So this is an example where, of course, fundamental rights to engage in peaceful protest, freedom of association, if you like, human rights, are given explicit protection. So it's, and when people are detained within the framework of this Act, as in India, they must be brought promptly without any, at the earliest practicable time, delivered to police custody. Again, reinforcing the point that civilian authority prevails. So obviously, getting to the heart of these powers and the controversy around them, it's immunity. And there is no doubt that Part 3 AAA confers immunity on the military for actions taken under the Act. And obviously they can use force, up to and including lethal force, and they are immune from both civil and criminal liability. Having said that, there are constraints. An ADF member cannot use force unless, so there's a prescription on using force unless certain conditions are satisfied. So in this context, the law is seeking to guide the decisions of the ADF, the Australian Defence Force, on the ground. So you can't use force unless 4 conditions are satisfied. That the order to give force, to use force, is not manifestly unlawful. Secondly, that the member, the ADF member, the soldier on the ground, or the pilot in the F-111, has no reason to believe that the circumstances have changed in a material way since the relevant order was given. So it's, in a sense, reiterating the importance that the key frontline decision makers are using their own judgment and not simply slavishly following orders. The member has no reason, the third condition, the member has no reason to believe that the order was based on a mistake as to a material fact. And finally, that the taking of the measure was reasonable and necessary to give effect to that order. So you can see that there is a strong legal framework that is guiding decision-making of those people who are called upon in very difficult situations to make decisions that will sometimes involve the taking of innocent lives. Probably most contentious is the power to use lethal force to protect critical infrastructure. And it's quite possible to envisage a situation where a plane is shot down because it was threatening a security installation that in fact is unmanned. So here we're saying we're valuing, if you like, the lives of the innocent passengers on that plane against the importance of that vital military installation. There are lessons to learn from this in relation to European case law. And in fact, in Germany in 2005, which had a similar law which allowed the shooting down of hijacked aircraft, as in India and Australia, was held by their constitutional court to be in violation of the right to human dignity. That you couldn't, in a sense, trade the lives of innocent individuals in that circumstance because of the importance of the right to human dignity. In Germany, for a whole range of reasons, historical, that right, the right to human dignity, is regarded as a fundamental and paramount human right. Obviously, in our system, we've decided to weigh that differently, and we don't have that jurisprudence around human dignity. So, in relation specifically to the use of force decision-making, it's clear that you can't, as a defence member, do anything that is likely to cause death or grievous bodily harm unless the person believes on reasonable ground that, again, 3 factors, that it's necessary to protect the life or prevent serious injury to another person. That extends to the life of the ADF member, the soldier or the pilot. That the doing of the thing is necessary to protect critical designated infrastructure against the threat of damage or disruption. That is one of the more contentious powers. Or the doing of the thing is necessary and reasonable to give effect to an order under which the member is acting. So you can see clearly the immunity takes the framework of legal liability outside state and territory law. In Australia, our criminal law is not governed by one act. We have a federal system, as Saskia alluded to, overlain by a state and territory system. So we have effectively 9 criminal laws that are competing. This act clarifies that the state and territory criminal law has no application, as long as the military are acting within the framework of the law. The state authorities still have a role in investigation of any action that leads to death or otherwise a criminal offence. But the key decision in relation to prosecution is taken by our federal Commonwealth Director of Public Prosecutions. So we have a kind of a melded system here of civilian oversight of the military. We haven't left it entirely to the framework of our ADF military law and military justice system. So you can see that we've not favoured a blanket immunity. It's a conditional immunity. It has to satisfy a range of thresholds. And obviously training in the ADF around this focuses on those key statutory thresholds. So when you convert the law into in effect rules of engagement, ROIs, you're taking into account all of these factors. So I think you can say that there is more legal clarity for frontline respondents in Australia, and they're not left to the vagaries of a retrospective assessment of whether we should prosecute or not. They actually have greater legal assurance when they're called upon to act. So drawing some conclusions, I think I can say quite confidently comparative analysis of counter-terrorism and security law is not without its challenges and potential controversies. Not only do you have to have technical knowledge of different systems of law, but you also have to have a serious commitment to understanding the history and context of these powers, and an appreciation that simply a solution adopted in one country, whether it's Australia or India, is not necessarily universally applicable. That said, I think there's a real value in comparative learning, and public policy people would talk about policy learning in other fields. And it strikes me as quite interesting, and it's just a general observation, that in the field of terrorism and security law, there isn't much policy learning going on as there is in other fields, and that there is a kind of a parochial aspect to all forms of security models. I mean, Part 3 AAA isn't the same model that's adopted in the UK, and if I could equally give a similar presentation in the UK or Canada. So I think there needs to be a much more serious engagement across borders and sharing of lessons. So I want to make 3 final observations that we can draw from our analysis. The roles of the modern military within domestic borders are changing. And the military are being increasingly called upon in liberal democracies to perform a whole range of internal roles. As an adjunct to policing and public order, I mean, you see that in relation to the G20 and the Commonwealth Games in Australia. You will see those powers being exercised quite extensively, I have no doubt. You also see them most controversially being used in 2006 in relation to some crises in our Aboriginal communities with concerns about widespread crime and violence against women. The troops were deployed for nearly a year to bring about greater levels of public order and stability in those communities. So we have the same kind of controversies about when it is appropriate to use the military. But it was felt that the territory police forces couldn't stem the crisis. And in that context, the military were called upon. So I think the second observation is the mere presence of the military on the streets is not necessarily a sign that civilian authority has been displaced. I see that reading this, the debate on this in the, I have to say, a fantastic collection of essays. This is clearly being debated here at the IDSA, the Armed Forces Special Powers Act, the debate which was published last year. You can see clearly there is often a discussion about emergency powers and states of exception. It strikes me that a lot of this legislation doesn't have to be framed in these terms. These are civil contingencies. These are disasters. The framework for legislation doesn't have to deal with just one aspect of the use of the military. It can be much more broad-ranging. And I think it is absolutely vital that democracies like India and Australia have modernised legislation. I think one of the papers said this act is actually a legacy of, and basically a colonial inheritance taken from the special powers models that were pre-independent India. Clearly, modern legislation set out in advance that sets out the balance that's needed to be done between enabling the military to give assistance as required, whether it's to law enforcement or to emergency services when there's a flood or a fire, as in Australia. This law has to be worked out in a modern framework. So it seems to me that that will provide benefits in terms of assurance to the military on the ground that when they have to use force in extreme situations to combat terrorism or organised crime, I mean, we've actually seen our military deployed recently to deal with the motorcycle gangs in Australia. First time really ever that we've seen our military deployed on a policing operation, because they know that they're going to be facing heavily armed gang members, outlaw motorcycle gangs, who will have serious firepower, and that is beyond the capabilities generally of a non-paramilitary police force, which tends to be the nature of our state and federal police. So finally, I think the key issue here is also blanket immunities aren't desirable. Clearly, they should be conditional, and I think that is clearly an important factor in a modern democracy, that any defences that are created are ultimately circumscribed by law. But in the end, ultimately, the legitimacy of the military on the streets is going to rest on public confidence in the ADF. And it is a striking thing, just to quote a recent poll, one of the most highly respected professions in Australia is in fact the ADF. And I think that's one of the reasons why when they're called out in disasters, that there is little concern about that they're there to help. And generally that goes to assist in upholding their public confidence, much higher than politicians, much higher than media, and much higher than lawyers, all of whom trail much further down in the list of public confidence in the wider community. So I think it's vital that the military receive training when they are deployed, that they are politically and culturally sensitive and adequately trained in relation to human rights. So I think just by way of a final comment, India in many ways is better placed to develop legislation that is human rights friendly. Its constitution actually seeks to uphold human rights in a way the Australian constitution doesn't. Australian constitution drafted at a different time was completely silent in relation to human rights. And we are probably one of the only Commonwealth jurisdictions that continues not to have an entrenched Bill of Rights or human rights legislation. Nevertheless, we have human rights acculturation, if you like. We are highly sensitised to issues of civil and political rights, as is apparent when we're drafting our legislation. Old colonial-style emergency powers inherited from Britain, what we could call a martial law model that simply seeks to define powers and roll them over on a temporary basis, on an emergency basis, similar to those that were utilised in Northern Ireland for nearly 40 years, do not pass muster today. So I hope that our lessons from Australia may at least cause pause for reflection, that these are difficult and controversial issues, but we don't need to confine ourselves merely to critique, that we can actually move beyond a human rights critique to look at other models from other countries to see how we can develop a new system, a new set of laws for controlling the military when they're called out to assist in aid of civil power. Thank you.